topic this time is Beyond the Buzzwords, Understanding and Applying Technology to Your Litigation Workflow. This webinar is hosted by the ABA Legal Technology Resource Center, and speaking today will be Mike Hahn. The Legal Technology Resource Center is an ABA member benefit provided by the ABA's Law Practice Division. The LTRC has been providing lawyers with legal technology guidance for more than 25 years. You can find a variety of legal technology articles, guides, videos, and other resources on our website at lawtechnology.org or our blog, lawtechnologytoday.org. Mike Hahn is the Senior Director of Product Management and an original founder of Verdict Systems, the creators of Sanction. He has provided consulting services for such landmark matters as United States v. Timothy McVeigh, Washington, D.C. Sniper Task Force, and United States v. Tierco, the Enron broadband trial. In addition to consulting, Mike is a frequent speaker at industry trade shows and continuing legal education events. Mike has guided the company through 2 transitions that led to Sanction becoming part of LexisNexis Litigation Solutions. In his current role, he acts as the advocate for the market and the end user for product development. Thank you all for joining us, and we'll now begin the webinar.
Okay, thank you very much. So today what we're really going to get to the bottom of is I know there's not a single day that goes by that I don't get an email in my inbox that talks about big data, that talks about some kind of technology thing. And unless there's something in that email that immediately catches my attention of a problem that I'm currently having, I normally just hit delete and move on my way and don't even bother to read it. And I think one of the reasons why I hit delete more often than I read things is because a lot of times these emails come to me with big giant buzzwords called big data, called things like that I just kind of look at as a very generic term that doesn't really apply to what I'm doing. So what we're going to do today is we're going to peel back a lot of those buzzwords and a lot of those things that we see in those email subject lines and really take a look at what's really going on behind the scenes and understanding what technology is really out there, and more importantly, what problems that we really handle or what problems that we encounter throughout the life of the litigation that these technology solutions really help us solve. So what we're going to go through today is we are going to talk a little bit about the flow of evidence, about some of the events and some of the things that happen early on in the litigation process and how our workflow has really evolved over the last 8 to 10 years. We're going to talk about how mobile and handheld devices have now made a giant impact on that workflow, some of the good things, some of the bad things, and then dovetail that into talking about how the presentation of evidence is not only affected by these first 2 items, but some best practices and some things to work on as we followed that workflow all the way through, and now we're heading off to doing a presentation. So one of the big things that we always see and always hear about in discovery is about the pace of big data, how much data has changed our stuff, and how the avalanche of data that we're consuming flies at us to where our cases are becoming more costly, more risky, and much, much, much more complex. And one of the things that I always sit here and think about is I'm like, okay, what does that really mean? What is big data? Well, this is some catchwords and some things that we see in some surveys and some different things, just to give you an idea of the scope of what we're talking about. And then I'll really kind of hopefully bring it home to really what it means. So the one here on the right-hand side, the 15 out of 17 sectors have more data stored than the Library of Congress. I remember growing up that a phrase that I heard a lot as to compare about what you were collecting is, yeah, you got more data than the Library of Congress. Well, you know what? 15 of 17 business sectors now can say that, or back then it was just the Library of Congress. Our electronic stored information is expecting to more than double every 2 years until we get to the point where we're talking in terms of zettabytes, which is 1 trillion terabytes. Now, when we hit 2020, we're not talking about cumulatively 35 zettabytes of information being stored that's been collected up to that point in time. We're talking about 35 zettabytes of data being created in that year. So you can see how big this is really exploding. So what is big data really? Let me just kind of bring it home like this. So just think to yourself, not only from your perspective inside of your law firm, but also the people that work for your law firm. So do you have a LinkedIn account? You probably more than likely, very likely have a company email address. You probably have a personal email address. You probably got a Google, a Gmail, a Hotmail, a web.com, some kind of email address that you're trading personal information back for. In the case, if you're like me, you might have multiple personal emails that you have, one for junk and one to actually communicate with people that you want to communicate with. You have a Facebook page, Instagram, text messaging. Now you start to think to yourself, out of all those mediums and all those different pieces of devices and information that you have, how much information are you producing every day? So now when you take how much you're producing every day and you multiply that by 10 inside of a company, a small organization, inside of a small law firm, maybe you've got 1,000 employees, maybe you work for a company that's got 15,000 employees, maybe you're talking about 300 million people in the population of the United States of America. Now you really start getting an understanding of why that big data avalanche is continuing to build on top of one another. So if we have a case where we start getting complex data sets, we start getting emails sent to us that are part of the discovery process, what are we really trying to do with that stuff? And so all this technology in here that says, how do you handle big data, what are we really trying to get to the bottom of? So one of the first things we want to get our hands around is what we have in that data that comes into us and what's happening at the early parts of the case. So after we've met with our client and after we've sent out our discovery request and we start getting discovery coming in and we're starting to get our documents from our own clients, we're starting to get elements of these big data sets. So you're going to hear the catchphrases that you hear around this early piece. You hear kind of two words talked about, or two sections of it. It's either early case assessment or early data analysis. What we're trying to get our arms around is what do we actually have in this data set. And at this point in time, we're not trying to look at everything that we have. What we're trying to do is, can we take that very large set and can we make it smaller? So the first thing we want to take a look at is, can we get rid of irrelevant data? So if we were taking a look at the Enron case today, 12, 13 years ago when discovery was going on in that case, it was a lot of printing things, trading paper back and forth. Now what we would do is we would go point some early case assessment or some early data analyzer technology at that data set, and we would want to see where, say, all the emails came from. And if we take a look at where all those emails came from, we're going to have a bunch of them that are going to come from, say, Enron.com. We immediately want to make sure we put those aside because we're going to want to review those. But if we start seeing emails that are part of, say, MSN.com, we can take a look at a couple of those and probably quickly assume that that stuff is really junk or spam that's coming in from third-party sources that are really not relevant to our case. So can we make an intelligent decision at that point in time to dump a whole section of emails out? And that's really what this early case assessment is doing when we're eliminating irrelevant data. Can we get rid of duplicate data becomes the next question. So you start seeing a lot of companies that are sending around things saying, hey, we have email threading technology. Well, what is email threading? Here's really what it amounts to. So let's say I'm in a company of 400 people, and we have one of our key employees, Bobby, just had a birthday today. So somebody sent an email to Bobby and BCC'd or CC'd the other 399 people to say, hey, happy birthday, it's Bobby's birthday today. I'm sure you've all been on strings of this nature at some point in time. And somebody hits reply to all and says, yeah, happy birthday, Bobby. And somebody else says, hey, reply to all. Happy. Now all of a sudden, that initial email to 400 people now just generated 1,200 email messages because it was 400 times 400, 400 plus 400 plus 400 in terms of the replies to all. So what we can do now with email threading is we can say, instead of looking at the email that were in, say, my inbox, I want to regroup all these emails and take a look at them by threads. So I can now immediately take a look at that subject matter and see happy birthday, Bobby. I can look in the body of the email and say, you know what, this is all about some guy's birthday. We're going to take these 1,200 emails and we're going to set them aside and we're not going to bother looking at them because they're irrelevant to what we're trying to do. So instead of looking individually at 1,200 emails, we lump them together and throw them out of the way. Now we also have some technology that you hear a lot about, deduping or near duplication. So what we try to do when we're taking a look at near duplication of documents, let's say that we've got a case sitting out here that talks about, let's say it's an employment litigation. And through discovery process, we've received 100 employee contracts that are all in Word document format. What this near duplication technology does is we can look at one of these documents and we can say, okay, find me everything that's similar to this document. And what the technology will do is it'll analyze the data or the text that's in that document, and it'll group these 100 documents together and say, okay, here was your baseline document that you told me to base it on, and here's 99 more that are very much like it, that are 95% like this. So I can quickly look at that first one, and if we're dealing with, say, an employment case of this nature, our 5% differential is probably going to be name, address of the person, maybe some personal information about each individual employee. But if I can make a determination at that baseline document that this employment agreement is irrelevant to this litigation, I can quickly take all 100 of those and throw those aside and not have to worry about it. So email threading, near duplication are becoming very big concepts and very big tools at handling this electronic data avalanche. And then the last little consideration we have to make is how do we now take all this stuff and turn it into a review set? Can we turn them into PDF files, or do we have some court rules that we have to look at traditional image files like TIFF and JPEG? More often than not, we're probably just turning them into PDF files. So like a lot of other companies, LexisNexis does have tools that talk about this section of this early data analysis, and that's really what we're talking about when we deal with those types of catchphrases and those types of words. So the next piece of it then becomes after we've done all this stuff and now we've gotten rid of our irrelevant data, now we want to actually go through and review what we decided that was there. So you'll see from the first line there, the emails and attachment, we still have a desire if we decided that for whatever reason, Bobby's birthday email was relevant to this litigation, well, we might want to see those things grouped by subject so we can look at that set of emails and make a determination about each individual one, because maybe we'll find somebody in that email string that we need to go get additional discovery from that we didn't think about before. So a lot of times, if that 400 email to Bobby's birthday had an attachment to it, well, if it's the same attachment 400 times, we want to be able to get rid of the duplicate versions of the attachment and only look at that as a single exhibit. And then can we take those attachments and do we want to treat the email plus the attachment as a separate document, or do we want to combine them together and look at them as a single exhibit? We're still going to want to take a look at that duplicates and near duplicates. And then the other big technology that's really becoming refined as we've come along the way is this concept-based searching. And really, all concept-based searching, it's very, very simple. And I kind of liken this back to the Enron case. If we were taking a look at and we wanted to find terminology or text that existed where the directors and the officers of Enron continued to tell the employees to keep buying the stock, if I go take a look and search for the word purchase, if I'm doing old linear searching, it's just going to return hits that have the word purchase in it. But if I turn on some concept-based searching, these engines will say, oh, you said purchase, but you probably in this context also mean buy, acquire, or other synonyms of actually buying or purchasing something. And then after we're done with this review process, then the biggest step that we take from the evidence discovery and review is to make sure that we can redact things when necessary. If we're redacting images, can we also make sure that that text behind the searchable text gets deleted as well if it was redacted? Or can we just do PDF support or PDF productions? Can we send that stuff out and get that in? So in a nutshell, from the analysis of the early data to doing our review and our production, those are some of the big catchphrases that we're dealing with right now and some of the big things that we're talking about as we move into the next generation of this technology. So that linear process that I just described, where we go from electronic evidence into review production and potentially into presentation, the industry has put together a model around this, and they call this the electronic discovery reference model. Now, I have struggled sometimes with understanding what this model really truly means, and I'm sure most of you do as well, because this is more of a complex, complicated process. And when people come to us and say, hey, here's the EDRM, or here's the electronic discovery reference model, what they're doing is they're giving it to you in buzzwords in the industry, and they're not really truly addressing your workflow. Because what we really want to understand from the legal perspective in our workflow is not only this process that we just walked through about how we take electronic evidence and we get it and we produce it to the other side, but how does this evidence that we've now collected and reviewed, how does it affect what issues we have in the case that we're trying to prove and defend? How does it relate to the facts in the case that we've already kind of maybe started to put in a chronological order? How does it affect what depositions I need to go take and the testimony I need to get? How does it affect my ability to prepare my own witnesses? How does it affect legal research that I might be needing to do around this case? And ultimately, how does it affect my ability to organize, mark, and walk into a courtroom or walk into a proceeding of that nature and get a piece of evidence admitted? So that's really the piece when we start talking, when you hear EDRM and electronic discovery reference model, the buzzwords in the industry are missing this key important component of what goes on in our case. Which leads me to really what's changed. When I think of the EDRM model and that electronic discovery reference model, this is what I think of. As I think of this mess that sits in my office every single day, and how do I make heads or tails out of it as it relates to a litigation? Well, we're really talking about dealing with a few key sets of information during this process. Is we're dealing with our documents that we still might get in hard copy. We're dealing with our videotape depositions that we've taken, our sticky notes and our memos to the file and how we've managed our information before, color photos, deposition testimony that I need to go highlight or annotate or make designations on, and then PDF files that the opposing counsel kind of sends to me. And while we talk a lot about big data, what's really changed in our business over the last 8 or 10 years is what we do with this information that we collect. What we typically have done in our legal space, in our technology products, is we take everything and we might have an issue management tool. And in many cases, our issue management was historically just a memo that we write to the file and we stick it in a file cabinet. And that's how we share our thoughts and ideas about the case. We take our document management solution that we might have and we put those things in there. And then we might have a method, whether it's via PDF or via some standalone viewer that a court reporting agency sends me, we might have a way to manage through our depositions. And so we viewed this information in distinct silos as we're working our way through litigation. Well, that's really gone upside down now. So what this has all led us to, this onslaught of the bigger data sets, this workflow-specific application of what this technology means, it's really led us to this. And as I'm sitting here today trying to work my way through a lawsuit or work my way through litigation, my cases are no longer viewed in buckets like this anymore. It's now, how do I manage this information across an entire subset? Because I'm not getting just paper, I'm getting inboxes, so now I've got complex data I've got to deal with. Somewhere along the way, the court reporters started linking our deposition exhibits to the actual transcript. So if I'm a person that historically has gone home and highlighted a hard copy of a deposition, that highlighted section that I'm making over a hard copy, or even a highlighted section I might be making on a handheld or a tablet computer, those might now be linked to pieces of evidence that I've collected that might now be linked to a witness that's going to talk about those. Once I've gone through and done all this document discovery, the document itself is not really the important piece. It now becomes a paragraph on a page of a document that has a relevant fact, that has a relevant finding in it, and that paragraph needs to be linked to a witness that's going to talk about it, linked to a issue that I have to prove and defend, linked back to deposition testimony that I've taken in the case. So it's really now about managing the intertwining of all this information instead of looking at everything in subsets. So most companies now, including LexisNexis, we are developing technology around how we manage and how we handle this entire subset of information and how we give the inner workings, and we can show the relationships and we can have users establish those relationships. Because I can have the best tool in the world to process complex data sets from somebody's inbox, but if I can't take that information and make use of it as part of my litigation workflow, I'm not really going to get anywhere with it. So with all that said, let's take a look at what's going on in handhelds and mobile devices in our space, because this is really changing every day. And what we're going to talk about is we're just going to go through what's going on with the global market share. I mean, we all may have our personal preferences of an iPad or a Windows or a Google-based one, but I want to show you a little bit of what's going on by device in the larger market space and how that works in terms of what people are buying today. What some of the court rules are, how we're handling those. We did a survey within the company about handheld devices and what's going on within the trial, and I'll give you a very quick overview of what's going on with each of these devices and the operating systems and some of the good or bad of each of them. So this is what's going on in with the top worldwide, the tablet vendors. So these are the people that are actually making the hardware. So Apple obviously has their own operating system. Samsung is really basing theirs on the Android or the Google-based operating system. Amazon is also based on the Google Android. Asus, Lenovo, and some of the others are going more towards the Windows-based operating system. So what I want you to take a look at here, just as kind of an interesting side, is take a look at how Apple has declined in a year time frame, but how much Samsung has gone up. And if you take a look at these tablets from what operating system they have, the Droid Google operating system owns well over 50% of the market, where the Apple operating system actually only has about 35% of the market. So it's really an interesting dynamic, because over the lifeline of when tablets first started getting introduced, Droid, largely powered by Samsung and others, has started to overtake the Apple iOS in a worldwide market. But I'll get into some of the implications of that in terms of what we're doing in a second. And this is just the last quarter of last year, so October, November, December of 2013, when we were talking about new shipments, this is what people were buying. So Samsung and Amazon together, you see there's about 20 million that are going out with the Droid operating system just in those two manufacturers. So Apple, while it seems like they've got such a dominant market share, which individually they do, if you take a look at them compared to all others, it's actually only about a quarter of the market right now. So what's going on in the courts right now, and I'm sure you've all been to this, is what can I actually bring into a courtroom and what can I not bring into a courtroom? And there's a big debate amongst courts, and what we're finding is that rule by rule, court by court, judge by judge, it's very different depending on what jurisdiction you're going into. So I went onto our research tool, and I studied and looked over about 11,000 hits at a very high cursory level of what's going on in terms of the court rules around there. And so there's a debate taking place, and should we allow you to bring anything and everything you want to in the courtroom, or should we really start to limit you even more of what you could bring into a courtroom? So this is the argument to let you bring anything and everything. More than 280 million people have mobile devices, and almost every single one of them has a camera. So if we tell you you can't bring a camera into the courtroom, well, that also means you've got to leave your mobile device back. But most of you, as I do as well, probably think that the mobile device is a very important tool for doing your job. And if you've got to run out during a break and make a phone call, can you even find a payphone anymore? So you need it to make calls. Electronic courtrooms are becoming more common, but I'm sure you've all stood in front of a judge and they said, well, let's take a look at your calendar to set the follow-on hearing. Where's your calendar now? It's on your handheld device. It's on your tablet. It's on your phone. And if I can't bring that into the courtroom because it's got a camera in it, then I have trouble accessing my schedule. So that's where the people are falling down and being able to say, yeah, we just need to loosen these rules and bring anything in that we want. What are arguments for stricter rules? Well, filming of proceedings, taking pictures of jurors, closed proceedings in the privacy of the parties is a major, major, major consideration of judges right now. And this is probably the top reason why they're still very limited in what they can bring. They're also concerned about noise disruptions and giving internet access to jurors in real time. But for the most part, the primary reason is really driven by privacy of the parties in the proceeding, which is why we see more often than not they're actually allowing attorneys to bring stuff in, but they're more than likely going to limit what the parties can actually bring in. So what this survey really means, and we're going to kind of take a deeper dive into it now and talk about what's going on actually in the courtroom. This was a survey that we did amongst all law firms. Up to we had about 400 respondents, equally divided between very specialized law, which was 0 to 10, 10 to 50 for mid-sized law, and then large law being anybody greater than 50. And what we found was that nearly half of you across this survey said that at some point in time in the future you were going to use a tablet or a handheld to do some level of your courtroom presentation. So what we wanted to get our arms around, and what we've been, with the research we've been doing kind of individually ever since then, is if you want to take that step and this is the direction that you want to go, we wanted to uncover what some of those problems you may encounter and how we can get around them. So this is what the people that, there's about 25% of them that surveyed that said, yes, I've already used a handheld device to give a courtroom presentation. And here were some things that they told us that they were having problems with. Internet access. Even though we walk into a lot of courtrooms right now, internet access in a Wi-Fi or a wireless environment can still be somewhat spotty. So if the presentation is a hypercritical presentation, which most of the time they are when we're given a courtroom proceeding, do we need to be relying upon the internet to do anything? Issues with battery life, I put that in there, but I kind of don't chalk that one up because most of our handheld devices right now really have really long battery life. So that's not really that much of an issue. Somebody must have let their kids play with the games on it before they walked into the courtroom and sucked the battery life down. Difficulty getting documents loaded onto the handhelds and problems displaying the evidence. So when you start getting in, especially in the iPad environment, they have a very specific definition of what types of data they can bring in. So if you're going to bring in very specific video or very specific PDFs or specific types of documents, you're going to be in pretty good shape. But the moment you need to deviate across those standards, getting information, documents loaded, and displaying that evidence is going to be very, very tricky from a handheld device. And one of the biggest ones is really around security concerns. While a lot of offices and a lot of firms and a lot of companies in particular have adopted this bring your own device to work technology, where you can bring your own device, they can connect it to the network to where you can get your email, but a lot of times they don't want you to plug into their network to download client data onto that, and there's some other security concerns that go around that. So we are still seeing some security concerns kind of fall across the board about being able to implement this stuff. So we talked a little bit about the survey, but here's really what's going on out there. So the most common operating systems that we're now seeing across these handheld devices are really iOS, which is Apple, Android, which is Google, and then the new Windows 8 device, which I'll talk a little bit about in a second. It's about a year old now, but there are a new Windows 8.1. And you start to see devices from iPad, Microsoft, Dell, Android, Samsung, Sony, Google, Kindle. They're all over the board. Everybody's now getting into this manufacturing business. Just try to walk through Best Buy or some other shop like that right now and just see all the different flavors. It is very, very confusing right now if you try to go out and buy a non-Apple-based handheld device. So what's out there and what's good and bad? Well, the iPad is obviously the one that we all know of and we all hear about. The good news about the iPad is they have a lot of legal-specific applications for us. It's very good for reviewing content. It is a little limited in terms of when I say reviewing work product. So if you are typically working on cases all by yourself and your work product is largely going to be contained just to you to review, well, then you're in pretty good shape because you don't really have to share that with anybody. But once you need to take something off of your network, review it and do some work on it on your iPad, and then pass it back onto your network, there is a lot of issues with doing that type of work. There are transcript applications that have solved that problem, including one from Lexis, but there is still some work to overcome in terms of some of that work product. And then this last line is Office coming to the iPad. I was just scouring the internet yesterday. There was big news that came out in terms of Microsoft stock jumped through the roof, largely because news is now being reported that at the end of the month or next week, the new Microsoft CEO is going to announce that they're now going to develop Microsoft Office or release a version of Microsoft Office for the iPad. So some of those limitations we had with dealing with our work product might end up going away. I'm going to touch on this very quickly. One of the real limitations, we talked about the data specifics that you have with an iPad. This is a serious limitation as I see it if we ever have to walk into a courtroom and play video back. All I say is I copied and pasted this from a site that says they can do courtroom presentations with an iPad. And yes, you can play video, but this is what you have to know about video. Now, I can read that, and I honestly don't know. I can sort of tell you what that says, but for the details of that, I couldn't tell you how to produce a video that you can play back on an iPad. So just be very wary about that type of stuff when you're dealing with that. When you start getting into the Android market, there's a lot of different models available, but one of the shortcomings you see in the Android Google operating system model is there's very few legal applications. So if you're largely dealing with web-based applications inside of your firm, a Google or Droid device actually would work out very well because now you're just browsing to an internet connection, but there's very few apps, if you will, that you can install. Microsoft's big bet is on their Surface tablet, and they now have they've now got Surface 2 that came out towards the latter part of last year. So just to make sure you understand, Microsoft has two versions of it. They have the RT version, which is the true competitor to the iPad. It will run mobile applications, and it also runs a full version of a mobile Microsoft Office. If you need to take a desktop level application, if you want full connectivity and access to your network at your office, then you move over into the Pro version. And the Pro version gets more expensive. The Pro version 2 starts at $899. The good part about it is, though, is it does run a full version of Windows 8 where it actually can function like a laptop. And IT departments and large IT like this type of technology because of the fact if they're a Microsoft network where they're controlling the security from that perspective, then the Windows 8 Pro version, they can control the security on it a lot better. And they will allow you, IT staff will allow you, if they have a Microsoft network, to plug your Windows Surface Pro into your network and download data just like you would to a laptop. So there are some advantages to this and there are some disadvantages to it, but it's really interesting to see what's going to happen to this Microsoft Surface if typically you were going to buy a Surface if you wanted full versions of Office, but if the full version of Office is coming to an iPad, it's going to be interesting to see if that decreases the adoption of the Surface in the actual long run. So in the last couple of minutes here before we can open up for questions, I'll just get into a little bit of some ins and outs and some tricks of the trade about how we can deal with presentations. What I'm just going to focus on here is really around better execution. Part of my background in history is really about supporting technology implementation in courtroom, and these are some things that I've just uncovered as we've gone through all this data, even dealing with handheld devices, is how do we take care of all this and we make sure that when we're actually going to resolve this case, how do we pull all this together in the easiest, most efficient manner. So my big thing is always around equipment, is that if I have older laptops, if I'm going to go do courtroom presentations, warranties typically run out about every 3 years. I want to make sure I'm replacing a laptop about every 2 to 3 years. That's just generally how I like to do it. Keep track of your service periods on your projector. So if you're going to go out and buy a new projector or a new projector for your firm, I don't say keep it tracked at every exact detail, but just keep kind of a running total about how many hours that projector has been used. Because the last thing you want to do is have a projector that's been running for about 700 hours, and you're going to walk into a 2-month trial, and you don't know it's been running for about 700 hours. You run the risk of losing a bulb or having a bulb go out in the middle of that trial. I'm a very, very big proponent of mixing and matching presentation methods. Even though technology helps us out a lot, I still really prefer in certain instances to use boards, to use butcher paper to draw things on, to use whiteboards. Any way that I can keep somebody engaged to get them to a spot where I'm trying to educate them about our case or have them learn the facts of our case, I really like to mix and match presentation methods. And the last little thing that I kind of leave as a little tidbit is no one understands your technical limitations. Not only you, but your equipment. And prepare, prepare, prepare. You can never over-prepare for things like this, and never be afraid to reach out and ask for help. So with that, we're at the bottom of the hour here. I'll go ahead and, Rose, and open it up for questions that came in, and then we can take that piece.